Thank you, Maru. How are you?
I'm well, thank you. I interviewed you when you prepared the writ to serve on these persons and also went to the Supreme Court. You were very positive, where you said that the former president was a ward of Parliament, and you made that argument and said you were going to go before the Supreme Court and argue that out. Tonight, I'm hearing that you have been thrown out. Let me tap into your journalistic cap first. What happened in court?
Well, thank you very much. During your introduction, I think I heard you make the comment that the case has been gone into, or a comment to similar effect. The case itself, the writ itself that I filed before the Supreme Court, the merits of the case is yet to be looked at by their lordships. When you go to court, two things happen. You go with your case, the law on your case, and you go with the procedural law on your case. So that let's use an analogy of a room. I'm coming into Citi FM to speak. There's the road that I used to get into Citi FM, and then there's the law that also comes into effect when I get into Citi FM. What happened in court today was the road into the court, or the way and manner you file the writ, or the processes that attach to the writ. The lawyer for Mr. John Dramani Mahama and the lawyer for Mr. Bambagwin, the Speaker of Parliament, raised certain technical objections as to the validity of the writ that have been filed, not the quality of the writ, but as to whether a writ has been filed and whether the processes were properly filed. So that is why we dealt with in court today.
Okay,
that is what the court says was not up to standard and therefore struck the writ out. So the merits of the matter still stand.
But it doesn't stand anywhere now. It's been thrown out with the papers that you brought.
It's not in court, but it can be refiled easily.
Okay, but you know that as a lawyer, procedure is very important. And if you went to court and your procedure was poorly executed and that has been thrown out, you can't even say that the merit is still standing. It goes with it. Everything collapsed completely.
No, that is not the case. The procedure, as you said, is extremely important. In my view, what I felt, and in similar circumstances, people have said that what I felt really would have been forgiven by the Supreme Court. But there were two circumstances that we need to take note of. Mr. Tadiosori raised an issue as to the timing of the filing of the statement of case. I was late by 6 days. Apparently, the Supreme Court, in the case affecting Mr. Tadiosori had been late with a similar rate by 1 day, and the Supreme Court had thrown him out. It was going to be very difficult to somehow rationalize why he did not forgive a 1 day limitation and then are ready to forgive a 6 day limitation. So that one, I think that particular point had a lot of effect with the bench that sat on the case today. The second issue is that the statement of case itself, I had filed it as an attachment to an affidavit. Their lordships are saying that it should have been filed as a standalone document. So even though the statement of case was filed, it was filed attached to an affidavit. So the merits of the statement of case has not been looked at. But the fact that it was filed as part of an affidavit technically was wrong, and therefore they decided the case should be thrown out.
And the panel also gave you an advice, we are told. What did they say to you?
Mr. Justice Kuranchie, he started by reminding me of our long-standing friendship, and that is the fact we have had a very good friendship over the years. We used to communicate in terms of family. He used to send me Christmas messages. I send his family Christmas messages. So we have had this long-standing association. So he reminded me of that, and then he said that in some of these things, I need to have a senior to advise me on how best to file some of these things. I think it was an advice that is well meant. The law is a profession where you learn. You are constantly a learner. And since I came out of court today, other lawyers have called me seeking to know about the precedent that was started. It had to do with Mahama and the Attorney General and the citation for it. They asked me about what went wrong in court today. So they consider that they are also seeking to learn from today's experience on how best to make their cases in future. So,
but as a fresh lawyer, this will be an embarrassing start before the Supreme Court for you, wouldn't it?
It wouldn't be. Today's experience, you can't buy with money, Umaru. You cannot buy the experience I went to today with money.
This is your second appearance before the Supreme Court. The first time was to be convicted and jailed, and today you are embarrassed. That's what I'm asking. The first time you went not as a lawyer.
You can see that there has been an improvement, because the last time I would have been
so today
I would have been jailed, not so. So there has been an improvement. You see, this is the highest court of the land. There is no court past the court that I went before today. So if you are able to stand before that court and advocate your case and make your case, it's really an achievement.
Very well.
For me, what I need to look at is the positives of the experience today. And I still believe that the government of the case that I intend to prosecute, the government still stand.
Okay.
I still believe that the case should be prosecuted.
Thank you so much, Kuranchie, editor of the Daily Searchlight newspaper, also a journalist.